afternoon, ladies and gentlemen, and a very warm welcome to this, the fourth in the Institute of International Shipping and Trade Law's 2021 webinar series. Our subject today is distributed ledger technology and blockchain in shipping and commercial law. I'm Simon Rady, QC. I'm a barrister and also a visiting fellow at the Institute and honorary professor at the university. And it's my pleasure to introduce to you today a very distinguished panel. DLT and blockchain is going to change our lives, and to some extent it has already, particularly in supply chain management. Smart contracts are now a fact of life, and mercantile and commercial law and practice needs to catch up with these developments. In some United States there already exists some legislative or statutory framework for what they call a lex cryptographia, or rather more frighteningly, the new algorithmic legal order. Our speakers are going to walk us through some of the potential changes and areas for potential change. And we start with Law Commissioner Sarah Green, whom we're very honoured and privileged to have with us today, who I hope is going to be explaining to us the work that the Law Commission is doing on looking for that new legal framework for this new world. She'll be followed by Professor Andrew Tettenborn, my colleague at the Institute, who's going to explore three possible applications of DLT in the shipping industry, which is a pretty fascinating area. And third and last is also my colleague, Professor Barry Sawyer, the insurance guru at the Institute, I think I can call him that. And he's going to be looking at the impact of DLT on the insurance industry. And he postulates a question, which will be interesting to hear the answer to: are we going to see a revolution in commercial practice? So we start with Sarah. Sarah, are we going to see a revolution in legislative drafting?
I do hope so. That's what we have in mind. So thank you very much, Simon, for that introduction, and thank you very much for inviting me. It's a pleasure to be here and to be part of this discussion. These are very exciting times, I think, to be involved in this area of law. They're also very challenging times. I mean, I personally and my team at the Law Commission very much enjoy looking at this really important technological change. It presents huge challenges and gives rise to some really difficult questions, and some of which I'm going to talk to you about today, and also talk about our proposals, or the stage that our proposals are currently at in relation to those issues. Because in my view, the emergence of blockchain, of distributed ledger technology, of smart contracts, of the algorithmic ability to do things that in the past was simply not possible. It's a real opportunity to be grasped. I know that there are parties who don't necessarily see it in that way. And it's going to be a bumpy road, I think. There are already issues that come out of that are not always very appealing or easy to deal with. But I think what we really need to do is, as a jurisdiction, grasp the nettle, extricate all those really positive things out of this technology and use it to our advantage. So that's what the Law Commission is trying to do with its current proposals. So I will talk you through how that is going to happen. Now, what I should emphasize before I start is just to make it clear, in case it isn't already to everybody who is listening, what the Law Commission actually does and the way it works. I mean, I'll be relatively brief, but it's very important to make clear that the Law Commission is an arm's length body from government. And what that really means is that we are independent from government. I've seen us sometimes referred to as a government department. We are definitely not that. What the government does is it will ask us to look at particular issues, which we then evaluate in our own way, in an independent way. And the way that we do that is through consultation. Consultation is the key to what we do, which is why I really enjoy talking at events like this, because what we really want is feedback, is criticisms, is, well, approval if it's there and if it's genuine. We definitely want to hear that as well. But that's what we want. We want a response to our proposals, because there's no point in the Law Commission working in this intellectual ivory tower vacuum where we then push out these suggestions which might have no practical relevance to the people who have to use them. So it's really important to understand that if you have any view, and it's open, this consultation, it is transparent, it is open. If you have any view at all on what we are proposing to do, which is publish a consultation paper with draft legislation in the spring, please, please, please do get in touch and tell us what you think of it. You can do it in a variety of ways. It's online, obviously, if that's what you'd like to do. So that's what the Law Commission does. We do our own research, obviously, we look at these issues and then we consult on them. So the current issue that I'm going to talk to you about today, we're doing a separate project on smart contracts, and I may well come on to that if I have time. But given the objectives of this institute, and given the other speakers that you have here today, I'm going to focus on the project we currently have, which is on digitised trade documentation. And although it might seem quite surprising to some people that we're in this position in 2021, it remains the case that there are legal blockers, and significant legal blockers, to commercial parties using digitised documentation in the same way, I should say, as they have always used paper documents. So essentially, we're in that position where really the law has not kept up with technological, economic and commercial developments. It's very clear that what commercial parties want to do is to use digitised documentation to a wider extent than they currently do, and for it to have exactly the same legal effect as paper documents, because of course we all know that they're already doing this, but it doesn't currently have the same analogous effect or rather doesn't have an analogous effect, I should say, as paper documents. So our remit in this project is to remove the legal blockers for that to happen. And essentially what this comes down to is a question of possession. So we have distributed ledgers. We now have the ability, as a result of blockchain technology, we have the technological ability to produce electronic documents which in many ways are physically analogous to paper documents, in the sense that they can be unique, they can be exclusively possessed, they can be transferred in a way that other electronic documents, which are of course very easy to copy, very easy to replicate. So blockchain has enabled and facilitated digitized documents to perform the same function as a piece of paper, which of course, once I hand it over to another party, I no longer have it. And that's what the technology of blockchain has enabled us to do and enabled commercial parties to do. The problem is, so as I said, the law has not, common law concepts, and also there are definitions in several statutes, notably COGSA, Bills of Exchange Act. I mean, unsurprisingly, given that that's the 19th century statute, they presume and they anticipate that documents are going to be in a physical, tangible, perceptible with the naked eyes form, which of course is not now what is happening. But the problem is that those legal concepts depend on these documents being possessed and being amenable to possession. And of course, English law has its very peculiar definition of possession. And we know, as a result of OBG and Allen, we know that the common law does not recognise the possession of intangibles. Now, I could talk to you at length about why I don't actually think personally that digitised documents are intangible, but I also don't think that really matters. I don't think that's what's important. What I think is important is that actually, as a result of the development of distributed ledger technology, that those documents, whether you think they're tangible or whether you think they're intangible, they are actually amenable to possession in a sense that the common law can be and should be comfortable with, because we can now achieve that exclusivity and we can now achieve that transferability. So my team's project is about removing that legal blocker that a digitized document is seen as intangible. And if it's intangible, it can't be possessed. And if it can't be possessed, it cannot perform the same functions as a paper document of title, for instance, because it cannot be held, it cannot be transferred according to current legal definitions in the way that paper documents can. So you can see, I mean, we're all aware, I'm sure, of why and to what extent that is a legal blocker to what commercial parties want to achieve and what they're currently already doing. And at the moment, of course, the way that that is dealt with is to come up with a contractual workaround. So we can't, a digitized document cannot be a document of title in the same way as a paper document can be. So parties have various arrangements in place to reach the same outcome by means of a contractual agreement. But of course, contractual rights do not give you the same protection in all cases as proprietary rights. So it simply remains the case at the moment that digitized documents cannot do exactly what paper documents can. And we think that's what we want to change. Now, we thought the best way that this could be achieved legislatively is really to update the concept of possession just in an express way. What we're trying to do is the lightest touch intervention, because it's our view that actually this is a very significant blocker in its effect, but actually in terms of what's necessary to get rid of it, it's not huge. And so we want to be as non-interventionist as we can, because actually, as we all know, the law in this area generally is very effective, and we don't want to fix what ain't broke. So what we are trying to do is, as I said, have a minimal intervention, but achieve the most by doing that. And the way that we thought, and this is what we're very interested in consultation responses on, the way that we thought is best to do that is simply and expressly to expand possession to cover certain intangibles. Now, we certainly don't want to go as far as saying intangible things, you can possess them all. They're exactly the same in all cases as conventional, tangible things that we can hold, things that we can pass on, things that we can break. We're not saying that. What we have decided to propose at this stage is to draw out really from tangible possession what it is that's legally relevant about tangible possession. So until very recently, until the last 25 years probably, tangibility has always just been elided, I think, with possession, because everything that we wanted to possess was tangible. And so there was no question, is tangibility really the touchstone? It just didn't arise. Whereas, of course, in the digital age, it arises all the time, because the things that we want to possess in legal terms are no longer so obviously tangible. So the question then arises, is it tangibility that dictates whether something is amenable to possession? Or is it something else about those things which in the past have always happened to be tangible? And I think it's the latter. So what we're trying to do in this project is take out all those legally relevant things about tangibility, but to decouple possessibility, if you like, from tangibility. And to set those things out so that we can say where documents exhibit these characteristics, whether or not they're tangible or intangible, or whatever you think about tangibility, they will be, or they should be, amenable to legal possession. And they therefore have the requisite effects and the effects that commercial parties want them to have. And they use them in the same way as they do paper documents. Because in my experience, when I've spoken to stakeholders, and I've spoken to a lot of them now, so these are non-lawyers who use these documents every single day, they find it very confusing and surprising that they can't just use an electronic counterpart, an electronic version of something in 2021, and that it doesn't have the same legal effect. So this is surprise and frustration across the board. So we had to come up with, and this was the difficult bit, the fun bit, but the difficult bit, we had to come up with the characteristics that we thought were the legally relevant parts of tangibility, so that we could say where a document exhibits these, it will be amenable to legal possession. And that's the draft legislation that we're currently working on. But as I said, you might be sitting there listening to me thinking, what is she talking about? That doesn't sound workable. That doesn't sound like the best way to do it. Fine. As I said, we're at consultation stage, so please feel free to tell me what you think of these. But what we set out was 3 criteria, really. 1, something, whether it's tangible, so all of these are whether it's tangible or not. 1, something has an independent physical existence in the world. Actually, maybe I'll take physical out of that sentence, because that probably, sometimes for some people that complicates it, right? So something has an independent existence in the world. And what I mean by that is we're not talking about things in action, which of course only exist as long as 2 parties, well, it's dependent on the existence of a party. Whereas something like, say, a computer database, it is there in the world, a gold coin, it is there in the world whether anybody lays a claim to it or not. So 1, independent existence. And of course, most digitized documents we're talking about, that's just going to be satisfied anyway, but we put it in for the sake of conceptual completeness, or at least it's in our thoughts for the sake of conceptual completeness. The second characteristic is that something must be rivalrous. So something must be, it must be possible exclusively to possess that thing. So if I possess it, particularly obviously if it's a document of title, if I possess it, I don't want somebody else having the same rights. And of course, there are banks who would presumably agree with that very strongly. If I have possession of it, I don't want somebody else claiming the same rights over it. And the third criterion is related to that and will often overlap with that, and that is that something must be fully divestible, so that when I've finished with it, or when I want to transfer it or dispose of it or destroy it, although of course destruction on the basis of technology is at the moment probably won't happen very often. It's actually quite difficult to destroy something. But I'll stick with that for now, because the other thing that the Law Commission is concerned to do in this project is not to come up with proposals that are wedded to a particular technology. So of course, we want to future-proof them. And at the moment, blockchain looks like the way to do it. But in 10 years' time, who knows what the technology will be. So we don't want to restrict our thoughts to a particular technology. So it's fully divestible, which means that when I've finished with it, or when I choose to, I can transfer it completely to another party. So it's not just like a Word document where I could send it to Andrew, and obviously I still have it, Andrew will have it, you could send it to Simon, so on and so forth. That's not obviously divestible in the way that we want it to be. So those are our 3 criteria. And what we're suggesting: independence, rivalrousness or exclusive possession, exclusive control, I should say. Don't want to define possession through possession. And then divestibility. If and when a document, which of course is completely achievable through distributed ledger technology, if and when a document exhibits those characteristics, our proposals are that it should then come within the umbrella of the legal definition, the English law, English and Welsh law definition of possession, so that it then attracts all of the legal implications of that, and we know how important they are. So we've just changed that little sort of marginal edge, I would say, of the definition of possession. And by doing that, in our view, enabled digitized trade documentation to do what commercial parties or all parties want it to do. I'm aware my time is nearly up, so what I will say is that's the substantive part of what we're doing. In terms of time, our consultation paper and draft legislation will be completed in the spring, around the start of April, probably. And then, as I said, there's a 3-month consultation period that follows that, which is the time when we invite and expect and anticipate responses to what we've said. We then analyse those responses and produce a report with modified draft legislation, which has been responsive to those consultation responses. And that will be at the start of 2021. So we then, that will take the form of our final proposals to government. Government then makes a decision about whether or not to adopt those proposals. There's never any guarantee, but I would say that in this space, it's an area that government is very keen on reviewing. It's recognised that this is something that as a jurisdiction, we really need to be on top of, and we really need to be cognizant of the difficulties that would otherwise arise. Okay, I think that's my time up. I'm more than happy to answer questions later, including on our smart contracts project, which I haven't had time to talk about specifically, but I will now hand you over back to Simon, I think, and then over to my esteemed colleagues. So thank you very much.
Sarah, thank you very much. I found that really intensely interesting, and I think the battle about describing the possession of certain intangibles really a very interesting problem. Thank you very much. And who knew that you were so far advanced in the work that you were getting a draft bill in April? So that's very good news. And it's a shame you don't have time to talk about the smart contracts work, so perhaps we can talk about that over a coffee, virtual. Ladies and gentlemen, I'm now going to hand over to Professor Andrew Tettenborn, who's going to be talking us through the possible developments for blockchain in the shipping industry. I should have stressed when I opened this session that we are not only open to questions, we are imploring questions. So please use your Q&A function on the bottom and put any questions which come up. Our panel are extremely experienced and have guaranteed to me that they're prepared to take any question on DLT and blockchain. So really feel free to get the benefit of their advice. I therefore introduce Andrew. Andrew, over to you.
Right. Right. What I want to do is say briefly three areas of shipping where I think this is likely to be significant. Though, as will appear in two of them, I don't think that there's likely to be a great deal of pure legal significance. I'll explain that in a moment. Meanwhile, I'll see if I can share a document with you, which is always easier said than done. Oh, brilliant. Three possible applications of distributed ledger technology. To begin very briefly with what distributed ledger technology is about. Essentially, it's a technique under which data, information is distributed quite widely over a large number of interconnected computers. That was the best picture that I could find, which showed you roughly how it worked. The object being that monkey business, changing documents, forgery of documents, and that sort of thing becomes much more difficult. Indeed, it becomes essentially impossible, whereas it might be rather easier if a hacker could get to a single database contained in a single mainframe or single cloud computer and deal with the information on it. So what we're talking about is making documents proof against forgery and alteration. I certainly don't want to go into the serious details of blockchain. Apart from anything else, if I did, we'd be here for not 20 minutes, but probably several hours. Apart from anything else, I don't understand it particularly well either. I'm certainly no computer scientist. But that's the background. That's the sort of thing that we're talking about. Now, I said that it seemed to me there were probably three areas of shipping where this may, in the fairly near future, become quite significant. I'll go through them quite briefly. One is the case of accident investigation. That is where you've got, for example, a sinking or a collision or something like that, and we need to know what's happened. Now, currently, the investigation of shipping casualties, shipping events, is partly mechanized because, of course, of the existence of black boxes. And I did actually just get up a couple of pictures of black boxes there. As I think you all know, the black box actually is neither black nor a box, but never mind. It's a way of recording digitally everything of importance that happens on board a vessel. Now, one trouble with collision and accident investigation is that black boxes can disappear. There have been stories of black boxes being tampered with or quietly removed if they're likely to give rise to or give rise to something which might embarrass one or other ship owner or possibly somebody on board a particular vessel. Now, one way round this, of course, would be to make the black box data into a distributed ledger. In other words, have an arrangement under which the information which goes into the black box doesn't simply stay there in the black box as an equivalent of one central computer mainframe, but ends up being distributed over a DLT system or a blockchain system. And possibilities might be, for example, that black box data could be uploaded in something like real time to, say, a flag state authorities, or perhaps slightly more importantly, and this obviously would take a certain amount of argument with the IMO, but I can't see that it's impossible, an arrangement under which if you're going to call at a particular port in a state before you're given permission to do so, then you're asked to arrange that your black box data be shared with the port authorities at that particular place. And there are various other people with whom the black box data could be shared. I've mentioned charterers, possibly financiers who might very well be interested, and so on and so on. The object, of course, is to make the evidential side of investigating accidents, casualties, collisions a great deal easier. It doesn't involve a great deal of black letter law. What it does involve is making investigations very much more just a matter of seeing what the data contains, and in many cases, not needing to go a great deal beyond that data. I remember it was, I think, about 2 or 3 years ago that somebody remarked that for the first time, a collision action before the Admiralty judge, Mr. Justice Tier, the result of a collision action had turned almost entirely not on what we heard from grizzled seafarers giving open evidence in court, but from simply what people read from computer printouts, from computer graphics. And we're gradually moving towards this in collision cases anyway. I mentioned collision cases are turning increasingly on black box data. Those of you who are into serious wet shipping probably take to bed with you every night the CPR 614, which says that it's now a vital part of any collision litigation that there be early exchange of black box data, of VDR data. But what I'm suggesting here is simply that when it comes to establishing what happened in a collision, investigating what happened if there is a marine casualty, then use of DLT is likely to be quite important. Right, that's the first use. And again, it's not black letter law, but it's likely to be very important in practice. The second, the pictures did work. Cargo claims, and that includes both claims against the carrier and dangerous cargo claims against the cargo owners. Now, a feature of cargo claims, and I must admit they've enabled shipping lawyers to pay the school fees for quite a considerable time, but a feature of cargo claims is that very often the essential issue isn't really one of law, it's what happened and when. Did the damage happen on board the vessel or whatever? What happened to damage these goods and so on. Now, until fairly recently, about 15 years ago, this involved a great deal of expert evidence. Again, grizzled mariners coming into court together with experts of other kind, and to say, well, what probably went on in this container or whatever. Since then, we've come into the era of the smart container. Increasing numbers of containers now surveil goods within an inch of their lives, from the moment when the container is stuffed to the moment that it's unstuffed, being able to detect if the doors of the container are opened, whether the atmosphere in the container has changed, able to take photographs of what goes on within the container, and so on and so on, and probably also tell you where the container is at any particular time. And it's not only true of containers, it's also true of bulk cargoes. Increasingly, indeed, the IMO insists that bulk carriers, tankers, etc., have rather sophisticated monitoring equipment. Now, exactly the same argument applies here as applies with the investigation of casualties. In order to have efficiencies in finding out what has happened in respect of a cargo claim, what caused a particular cargo to set fire to the vessel or whatever, the more this information can be shared, and obviously we have to take into account commercial confidentiality, etc., but the more this information can be shared, and the obvious way to share it is using DLT, the more efficiently arguments of this sort can be conducted. And I think we're likely to see more sharing of it, monitoring data between, well, I said, ship operators, charterers, P&I interests, cargo owners, cargo insurers, and so on. The way to persuade people to do this being, of course, pointing out that it's likely greatly to reduce the costs of any dispute resolution. Now, that's cargo monitoring. Sorry, I got rather ahead of myself, never mind. But that brings us to what Sarah is really interested in here as regards the black letter law, which is shipping documentation. Now, I do have one thing which might actually cause people a certain amount of relief. The problems of being able to possess shipping documentation and its uniqueness and so on are actually slightly less serious than you might think. And the reason is this. As I say there, cargo documentation obviously lends itself to digitization. It makes cargo documentation easier to transport between sellers, buyers, banks, and so on. So if you can transfer documents in real time, that does actually make life much easier for everybody. The question is, are you thereby, if you give up paper documents, going to cause serious legal problems? And here I think you have to distinguish between two kinds of shipping documents. Essentially, the distinction is bills of lading versus the rest. Now, of course, the trouble is that professors of shipping law absolutely love the ocean bill of lading and spend a great deal of time on it. But it's worth remembering that increasing amounts of cargo, of course, don't travel on ocean bills of lading. They travel on things like ferry receipts or seaway bills. And I think you do have to draw a fundamental distinction between these two kinds of documents. At least we will if I can get the page down. Sorry, go back to that one first. As regards non-title documents, when it comes to seaway bills, actually, I don't think that Sarah needs to worry too much about them. Why? Well, I can't see any reason why a seaway bill at present needs to be written on paper. There is no need for a single authentic copy or set of copies of it. The function of a seaway bill is as a receipt and as the terms of the contract of carriage, but there's no law requiring a receipt to be a paper receipt rather than an electronic one. And there's no reason why you shouldn't have a contract made of electrons in the same way as you have a contract made of paper. And even when it comes to things like the Carriage of Goods by Sea Act 1992, that refers to the person named as consignee on a seaway bill. It doesn't seem to matter too much whether they're named as consignee on a paper way bill or an electronic one. And there's the other point, if somebody really wants a paper way bill, given that there's no single copy that has to be authentic, it's absolutely straightforward. You simply walk across the room to the printer that you keep in the corner and print out a paper copy. There you've got it. You've got the paper document that you needed originally. Bills of lading, of course, are the real problem. And this is exactly where blockchain is likely to be useful, because it provides you with precisely the ability to have a unique copy of the bill of lading, and as Sarah's just pointed out, the ability to divest yourself of the ability to control that copy, to transfer the ability to control it to somebody else, and so on. And that's absolutely classic blockchain stuff. Endorsement of a bill of lading is actually very like spending Bitcoin or Ethereum. There's another byproduct, of course. If we do manage to get electronic bills of lading, then perhaps we might finally get rid of the lunatic practice of issuing bills of lading in groups of 3, each of which is equally valid. That's a little bit of an advantage coming collaterally. The difficulty is this, which is that you'll never get all jurisdictions to recognize electronic bills of lading, or at least I don't think you will. Currently, there are enormous differences. We might just recognize them, but it's possibly unlikely, given that there is a power to legislate regulation to allow electronic bills of lading, which has never been exercised. Perhaps a government which is getting more and more used to legislating by decree might actually take a hint there. Some jurisdictions are quite cool with electronic bills of lading, and a very good example there is New York, whose legislation I think has a great deal that's worthy of copying actually there. But there will always be jurisdictions that don't recognize electronic bills, and there will always be the risk that a cargo will end up, whether you like it or not, in one of those jurisdictions. All you need is a ship to hit heavy weather, to put into a port of refuge and the cargo to be unloaded there, and to come up against a local judge who says, you know, what is this electronic bill of lading? Terribly sorry, but our civil code dating from 1883 doesn't recognize it. That may not actually be an insuperable objection. The real issue here is going to be the willingness of P&I clubs to accept electronic bills, because they're the guys who have to pick up the pieces when something goes wrong. It may very well be actually that the international group of P&I clubs, after some serious due diligence, if somebody did introduce a blockchain version of the bill of lading, it's perfectly possible that the international group of P&I clubs could say, okay, there is the problem of the goods ending up in a port of refuge which doesn't recognize electronic bills, but we're happy to take that risk in our stride. They've already done that with the older form of electronic bills of lading like Bolero and eDocs. I can't actually see that there should be an insuperable difficulty in their doing so in relation to blockchain-based bills of lading. I think I've just about had my 20 minutes, and I think it's probably best to stop there and leave any further discussion for questions. Back to you, Simon.
Thank you very much, Andrew, for that characteristically stimulating look at how shipping industry can adapt itself to DLT technology. Can the insurance industry adapt itself to the same challenges of DLT technology? And how will the insurance industry be impacted by these technological developments? Professor Barry Schreier is, as I said, the insurance guru at the Institute, and he's going to ask the question, and I hope he's also going to answer it. It's not purely rhetorical. A revolution in commercial insurance practice, Barrett, is it?
Thank you. Thank you, Simon. Very kind words. I hope I live up to the expectations and to the ability of the previous two speakers. I am not going to explain how the distributory ledger technology works. That has been done very brilliantly by Andrew. I'm not going to talk about general principles of law and how we're going to fit it into the current law. I think that's been the job of Professor Green, and I'll defer to those. But instead, what I want to do, I would like to say a few words as to how the DLT technology could actually change commercial insurance practice. And also, in that context, I would like to say a few words about whether the current framework is actually capable of dealing with the issue. When I say current framework, I refer to private law framework, of course. So it is believed that the DLT could potentially influence the development of commercial law and practice in three areas. One is underwriting, the other one is claim handling, and maybe in the future might enable insurance to be used more as an investment tool. And I'll explain what I mean briefly and how these would work in a minute. Let's start with underwriting. The idea is this. Let me just describe what the insurance sector is currently evaluating, whether it's plausible and whether they can deploy DLT in underwriting context with an example. Imagine you have a ship and you would like to obtain hull and machinery insurance for this vessel. What they are thinking is that there will be a private ledger which is actually open to brokers and trusted insurers. Essentially, it's going to be restricted to the people participating in that ledger. What will happen is that the party seeking insurance, probably the ship owner or ship managers, will actually collect data, will allow certain devices which have got sensors to collect data on the proposed risk, particularly in this case, the vessel. They could, with the sensors, monitor the condition of the vessel, maybe the navigational pattern of the vessel, and so on and so forth. And this data, which is collected, is going to be put on the DLT platform. Of course, that's not going to be the only data which is put on the DLT platform. The brokers will provide additional information which is vital for underwriting purposes. So any other information they deem appropriate or requested, such as the claim history, information on the ship managers, and so on and so forth, will be provided by the brokers, and the brokers will put that data on the DLT platform. The idea is essentially to create a kind of market where there are various underwriters who could assess this data put forward, the real-time data, so the data collected by the device or devices on the condition of the vessel, for example, and other data, and make their mind up whether they would like to offer insurance for that particular risk or not. The idea is basically in certain areas of insurance law, it's possible to collect all the data, put on one place, such as the DLT platform, and enable a number of underwriters simultaneously to look at this risk and consider whether they would like to offer insurance or not. And let's assume that there are 50 underwriters on the platform, and 4 or 5 of them are very happy to take a proportion of this risk. Maybe first underwriter takes 20%, second underwriter takes 20%, and so on and so forth. That's the model which people are actually contemplating. And there are some display models which has been developed by tech companies as we speak. Of course, in terms of the data provided on the DLT platform, there is no issue with regard to any data protection legislation, because this data essentially is data coming from corporate organizations. And as we know, the data protection legislation usually is directed at natural persons. So there is no problem in that sense. But nevertheless, I think there are a number of problems which this model could pose. Some of them probably technical problems, which can be addressed quite easily. Some of them are more acute legal problems. But I would like to sort of summarize what kind of main problems one can foresee. Of course, it's not limited to 4 or 5 problems I highlighted here, but nevertheless, I think it's a good start. I think one of the big issues in a model like that is who will own the DLT platform. It's perfectly possible that one of the insurers own the platform and invites other underwriters to join the system. Although probably that might not be a good business model, because I think the other underwriters would probably be feeling a bit uneasy if actually one of their participants owns this platform. So I suppose if this is the way forward, there is probably a need that a third party, maybe another entity, owns the platform and enters into a contractual arrangements with all those participating, such as brokers and insurers. So I think there is a possibility here for the emergence of a new type of tech company, which actually is going to be doing this kind of work for the insurance sector. And I think there are already those kind of tech companies operating in similar fields. So I don't think that is a particularly big problem. Another issue some might raise is that if you think about the logic of the DLT, the data is, whatever is on the platform is accessible by all other parties. And I think that could be problematic in the underwriting context, particularly after a number of underwriters decide to take the risk. So if 4 or 5 underwriters decide to subscribe to the risk, from the assured's perspective, you don't want the data which you place there for risk assessment purposes to be accessible to remaining underwriters at all times. But again, given that this is a private ledger, there is no reason technically why access to the database, the information on the database, could not be restricted afterwards. So for example, if after 4 or 5 underwriters subscribe to the risk, certainly those in control of the platform could restrict the access of the other underwriters to any further information. And I think that's probably essential from commercial sensitivities perspective. Again, this is a slight problem, but I think it's a technical problem which can be addressed. More acute legal problems could arise with regard to information missing or lost on the DLT platform. Even though a lot of computer scientists argue and say that DLT platforms are very safe, it is also a possibility, and risk managers are actually appreciating this every day, that the DLT platforms can be also subjected to a cyber attack. It could be possible, particularly with the advances in computer technology, to actually mount an attack, a cyber attack on the DLT platform and be able to extract information. Of course, this remains a serious risk. So if you are one of the ship-owning companies and you have information about your vessels on the platform, and a hacker manages to extract this information, that could be a problematic issue for you. There could be secrets, commercial issues you don't want to be sharing with the rest of the world, and that could cause you losses. I suppose this problem can be easily addressed if there is a regulatory regime, contractual regulatory regime put in place. For example, if all those parties joining the DLT platform get into a contractual arrangement where they allocate the risk of loss of data or risk of loss of certain issues on the platform, then I suppose that could be a solution. So I think the parties could find a solution to this kind of problems. Another difficulty could be what happens if the DLT platform malfunctions in the process of underwriting. For example, imagine that the brokers and the assured places the required information on the DLT platform as requested for risk assessment, but for some reason, when the insurers are actually engaged in the process of risk assessment, they do not get hold of that information because the platform malfunctions. In that case, what is the situation with regard to the contract? Is the contract concluded by the insurers? Although when they entered into this contractual relationship, maybe they were not in full sight of all the necessary facts, valid still. I don't think there will be any issue of validness with regard to such a contract, even if the insurers might be put in a difficult situation here because the data they use to assess this risk is not the full and complete data because of a malfunction in the system. The Insurance Act 2015 doesn't provide any answer specifically on this issue. But actually, if we go into the common law, there are precedents which indicate that if information is passed on to the agents of the insurer who are authorized to take that information on behalf of the insurer, and if they end up failing to pass that information to the insurer for risk assessment purposes, that information is deemed to be received by the insurer. There are a number of cases going back to the 19th century and even in this century, which highlight that. I do appreciate that the position is slightly different here. I do appreciate that it's not exactly the same as giving the information to an agent or putting the information on the DLT platform. But I suppose an analogy could be drawn in these cases, and I think it is not certainly the fault of the assured or their brokers that this information is not being taken into account. So again, I don't think this will be a problem for the assured. Of course, the insurers might be aggrieved and they might have a problem with the provider, owner of the DLT platform on the basis that as a result of a malfunction, they end up undertaking risks without fully being aware of what's going on. But again, that is an issue which contractually can be dealt with. When you sign up to the DLT platform, I suppose there could be a contractual mechanism, a corporate mechanism, which actually deal with this kind of issues and allocate the risks appropriately. So what I'm trying to say is I don't think there are serious problems, legal or technical, to use the DLT platforms for underwriting purposes like this. And I think in conclusion, maybe you could say these kind of platforms could work in a limited manner for underwriting purposes and could make the underwriting much easier and much efficient. As long as it is amongst trusted parties, as long as it is among brokers and insurers who sign up to a corporate structure, to a company, to a contractual structure as to allocate their risks appropriately if something goes wrong. And in fact, there is a platform already which is doing trials. B3I is a reinsurance platform, which actually tries to replicate this in the context of reinsurance. All the insurance risks are put onto the blockchain, basically, and the insurance treaties are drawn upon that and paid upon that. And it seems to be working okay in the context of that limited experience. So I think in some areas of insurance, particularly hull insurance, even maybe cargo insurance, it might be possible to come up with use for the DLT for underwriting purposes. But the message I would like to give here is, if that becomes a reality and common practice, I do not see why there is a need to intervene from the regulator's perspective. I don't think there is any regulatory vacuum here which needs to be filled in. Yes, there are issues, there are risk allocation issues, but these are adults, they're consenting adults, they know what they're doing, and if they're signing up to a system, I think certainly we can allow them to carry on with their business. Of course, the trick here is that all the parties signing up to this system and to the core governance regime must respect the governance regime and must not try to undermine the governance regime by taking their disputes to jurisdictions, because potentially any jurisdiction can be used given the far reach of a DLT technology. So for example, if you are an insurer from a different part of the world participating in this venture, potentially you might go to your courts and argue that they should look at a dispute between you and the platform provider, even though there might be an exclusive jurisdiction agreement, that they shouldn't do that. The court in that jurisdiction might actually disregard that. As we know, exclusive jurisdiction clauses are tight, but they're not watertight in all cases and in all jurisdictions. So as long as the parties actually can be respected, to respect the regime, I think it can work. And I think it can make insurance probably easier. But those in the audience who are brokers, please do not assume that you will be redundant anytime soon, because I think there is still a very important role for the brokers, even in a system like this. I think it cannot work without the brokers' input. So yes, it's positive in this sense, but I'm saying, don't worry, regulation is not a problem. The other idea of using a DLT platform in solving disputes is claim handling. It is being suggested that maybe dealing with the claims could be much easier now if we operate a smart contract over the DLT platform, where a claim is submitted and certain aspects of the claim is checked against certain parameters by the smart contract, and if it fits into those parameters, claim is made automatically. In fact, such a system in insurance, in consumer insurance, in some aspects of consumer insurance is already in place, particularly in parametric insurance. A great example is flight delay insurance. There are a number of blockchain technologies which are already being used in various parts of the world. The idea here is basically the cover is provided on a blockchain. The consumer don't even realize actually that they are dealing with a blockchain. They think that they are buying it online from a website, but actually after a certain stage, everything is passed on to the blockchain. And essentially you buy flight delay insurance. You say, I'm flying from here to here. If your flight is delayed, the public flight data is fed back to the blockchain about the exact time of arrival of the plane. So there are very reliable oracles here which can provide the reliable data for the smart contracts to operate. And essentially on receiving this information, the system checks this smart contract check against the original contract and say, okay, the flight is delayed. We have evidence that it's been delayed because these oracles, the public flight data, which comes to us, confirm that. And if it's within the parameters of the flight delay insurance, automatically payment is made into the bank account of the consumer. So of course, the question is, can we have this efficiency in commercial marine insurance context? So, for example, if you have on the vessels devices which are fitted with sensor and cameras and provide you regular updates, can you actually rely on that and operate a smart contract to deal with the claims? I think my answer is it's very, very unlikely in the context of commercial marine insurance that this would work. Because in the context of commercial and marine insurance particularly, you might suffer a loss, but there could be hundreds of reasons of a loss. For example, if the vessel insured is lost as a result of fire, okay, fire is an insured peril normally, but the cause of the fire might be an excluded peril. It might need investigation why the fire started. Was it a crazy crew member who decided to take revenge, who started the fire deliberately? Was it on the instructions of the insurer the fire started? There are so many other subjective elements in claim assessment when it comes to commercial marine insurance. For example, one of the aspects of commercial and marine insurance is that the assured is expected to minimize or avert losses through a labor obligation. Has he taken those steps? Has she actually tried to minimize the loss in the right way? Has she taken the reasonable steps? These issues might all come into the claim assessment. What I'm trying to say is in commercial marine insurance law, claims are not straightforward, like parametric insurance. Even in the context of reinsurance treaties, which actually they think it's easy to do, I'm not so sure. Because, you know, yes, you have a reinsurance treaty and you can have a smart contract. If you suffer the loss, automatically the reinsurer might pay. But, you know, the reinsurers might still need to investigate the claims you are putting forward. I mean, yes, you periodically declare this, but, you know, just because you declare them doesn't mean that they're correct. There might be a mistake in your declaration. You might be chancing your arm to a certain extent. And it's quite common in insurance treaties that parties actually, reinsurers might still need to check these declarations from time to time to make sure that everything is working. So even there, I'm not 100% sure that it will work with no problem. This is not parametric insurance. So I think this side, I'm not that hopeful. The third area which people think it might work, and I see the potential, is actually in the context of securitization of insurance. Basically, securitization is a financial technique that consists transferring insurance risks to operators, financial investors, by using various financial techniques. Essentially, you gather the risks and you turn them into notes on the capital market and you sell them. That's what it is. It is done today, or it's not like it's not done. But they're saying that if you do this on a blockchain basis, it might be done much more efficiently, much more easy, and it might accelerate this process. So actually, a lot of people are excited about this prospect of using digital transfer platforms to securitize insurance. I'm not, again, very, very sure at this stage. You might think that I'm a conservative chap who is worried about things and technology. But to be very frank, as far as I understand, so far, they have not come up with any platform which can cope with this kind of activity. And even if they do, I think if you go down this route, maybe not Professor Green, but another part of regulator, you will attract the attention of, because this is definitely going to get you into scrutiny of the regulators. You are here using the insurance as a kind of investment tool. You are entitled to do that. Insurers do that all the time. But nevertheless, I think if you start doing them on a blockchain context, in a blockchain context, at that magnitude, I think regulators quite rightly will want to regulate certain aspects of it, because it's perfectly possible that you can do legal and also illegal things in that process. So I think this is a nice fantasy at the moment, but it is a bit premature to talk about this at this stage. So what I want to say, look, my view of insurance market and insurers is that they are not shy people. If DLT tech will help their business and there is a clear economic benefit, like it could be in underwriting, they will use it. They will not have any problem. They will not be stuck in the 18th century, 19th century. They will use it. And, you know, we see that some attempts been made, and there are some platforms where, to a certain extent, this is experimented. And if they are commercially sensible, they will develop and accelerate. But my point is, as far as underwriting is concerned, I don't think that the DLT creates any significant legal problems which cannot be addressed within the parameters of private law. I think, and that's the beauty of it. I think there might be issues about smart contracts, but I think Sarah's work, the Law Commission's work, might certainly accelerate the use of smart contracts and might clarify a few issues which are outstanding in that sense. But I don't think there is a particular problem in that sense. But anyway, I don't think smart contracts in claim handling is easy to use in commercial and marine insurance anyway. I think I would like to finish with the words of a famous computer scientist who said, we always tend to overestimate the effect of technology in the short run, and we always underestimate the effect in the long run. I think we are at the overestimation level at the moment. I don't think technology has reached there yet of that magnitude, but certainly it will. And certainly at one point, things will change dramatically, but not anytime soon. In that sense, I would like to thank you for your time, attention, and would like to pass it on to Simon for managing the rest of the process. Thank you.
Thank you very much, Maris, for that very stimulating talk. We've run on slightly, but I think we've got time for a few questions. Thank you all very much for putting in the questions which you have. And so let's throw a question straight back to Maris, where one member of the audience says, aren't you being rather too pessimistic about the use of parametric insurance in simple, i.e. very common, basic marine insurance, for example, cargo insurance? And the question comes, surely the introduction of digitalized title documents, coupled with an increased use of Internet of Things devices monitoring cargo condition, could lead to an increased use of parametric insurance, avoiding the need for adjusters, claim handlers and lawyers, mass redundancies programmed, when you're dealing with ordinary cargo insurance, cargo sweat, cargo heat, carried on deck, matters of that kind. And presumably there will be a place for, in simple cargo insurance aspects, for the use of smart contracts to link all that up. What do you think?
I think so. I think there could. I think if something is going to happen in commercial maritime insurance, that's the prime candidate to happen. But of course, as you appreciate, even in the cargo insurance, things are not always that straightforward. It depends on identifying the exact cause of the loss. And sometimes do not forget that those kind of devices might malfunction as well. It might be possible that they might be tampered with. It might be possible because do not forget, this is not parametric insurance. This is not like you getting a data from a resource which you trust and facilitate payment based on it. The cargo might be in my favorite country, Hula Hula. And Hula Hula is a very corrupt country. And it's very possible that somebody might even try to nick the monitors you put or devices you put on the containers. So I think if something is going to happen, that's a prime candidate. But again, I'm slightly a bit cautious on that as well. But maybe that's because of my character. I don't know.
Yeah, I mean, speaking for myself, I think if you take an ordinary, very well-run container line with boxed cargo, a lot of data is logged anyway. You have a temperature measuring device inside certain containers. You have temperature measuring devices outside containers. You could put thermostatic probes inside cargoes to see whether they're going to overheat because of inherent vice. I wonder whether in 10 years' time we will have moved on.
I think we might. I think we might.
One more question before I go to other panelists also come in on the insurance front, which is what about in reinsurance? What is the possibility for a smart reinsurance contract when you're dealing with follow the settlements?
Well, I think that's why reinsurance is at the moment, testing this technology, because essentially you are absolutely right. If you are actually following the settlement, it can certainly lend itself very easily to a smart contract. My genuine concern there is that even when you are following the settlement, there is still a duty of good faith. There is still a requirement on the part of the party insurer to make sure that actually the claims are settled in a fair and equitable manner. And that could be challenged, or in some cases, the insurer have a view that it wasn't settled in a fair and equitable way, or it was done as a friend's job. And I think the problem will be in the smart contract. When you ask the smart contract to evaluate concepts like good faith, how is that going to be? I mean, some people tell me that in 5-10 years' time, the technology will develop so much that there would be artificial intelligence to assess this good faith, what is meant, and those subjective concepts. But that's my concern. That's why I'm a bit hesitant. So please do not take me as the enemy of the technology. I certainly want the technology and facilitate this kind of change. But I think, as the last slide suggested, sometimes we overestimate in the short term the complexities. And I think some of us in the sector, particularly tech companies, are probably overestimating how easy it will be. I can see why they're doing it, because it's their job. They want to sell business and they want to develop these things. But I think it will be a bit slower than people think.
Yeah, I don't think anyone would say that you're an enemy of technology. Barry's more doubting Thomas, perhaps. Okay, now, Sarah, a lot of questions are coming in, really not so much about what you've said, but about what you haven't said, which is about smart contracts, and whether you could give one question that ambitiously asked, can you give in 1 or 2 minutes just where we are on smart, or what your work is on smart contracts, and where it might leave the law of offer and acceptance? That seems rather a lot to ask you to do. But could you give us, say, 2 or 3 big points from what the Law Commission is finding with smart contracts?
Yeah, so the stage that the Law Commission is at with smart contracts, I'm just trying to think what the date is today so I can give you the right answer. So we've already issued a call for evidence on smart contracts, so it's available now on our website. So if there are people here today who have their thoughts on that, then please do look at that. So essentially what we've done with the call for evidence is we've spoken to lots of stakeholders who already use smart contracts and who want to use them. And what we're trying to ascertain is what needs to happen to contract law in order to facilitate these contracts, which again, like trade documentation, are already being used. And we want to make sure that as a jurisdiction that we can give parties the certainty and the predictability that they want, and they can rely on the the transactional integrity of these smart contracts. So that's where we are. We've outlined a number of questions in that call for evidence. And one of them is, of course, about offer and acceptance. So what we are talking about in the smart contract space often, and we saw this in the Singapore case of Coin, which I'm sure those of you who are thinking about smart contracts are familiar with. You know, really interesting question about automated offer and acceptance, and if and when parties, you know, is offer and acceptance, is the law relating to offer and acceptance going to have to change its temporal locus, so that rather than the point at which the contract is formed, you know, where there's a coming together of minds at that point, is it going to be the case, is it going to have to be the case that once you set up a piece of software or a program which will automatically accept another program's terms and conditions in the event of certain conditions, is that the point at which you make the offer? And is that the point at which the counterparty makes the acceptance? I mean, these are fascinating questions. They're very difficult. But if you look at Coin, that's one of the things that in terms of offer and acceptance, we may well have to come up with some modified rules of contract. I am certainly not a doubting Thomas with the technology, but in terms of, I was just listening with interest there to Farish's point about algorithmic transactions and, you know, discretion and good faith. I mean, I'm a big fan of smart contracts, and I think they have a really important part to play. I don't think for 1 minute that they should replace conventional contracts. So in our projects, what we are trying to ascertain is to what degree might we need, say, a separate, slightly modified set of rules for smart contracts without breaking, like I said, with digitized documents. You know, we don't want to fix what ain't broke. We don't want to remove certainty from those commercial parties who are still always going to want to use, in certain cases, non-smart contracts, conventional contracts. So offer and acceptance is potentially very difficult in the sense of at what point does that happen? So we've asked questions about that. In the call for evidence, we have also looked at remedies. Because, of course, the thing about smart contracts, the thing that really fascinates me is that, as we all know, most litigation about conventional contracts is about performance or lack of performance. And what you're not really going to get in smart contracts is a lack of performance, nearly so often, because that performance is automated and you are unlikely to get a computer which just decides it's not going to do it. And of course, what it might well do is do it in a defective way, if it has been coded in a defective way. So, you know, how does that fit with specific performance? How does that fit? Are we looking at an increased role for rectification? Of course, it's not really rectification because you can't change mutable code on a ledger. Is it some form of novation? So I think the remedies questions are really interesting. What I do think, I will shut up in a minute, I know I've answered this in a very long way. What I do think is really important is the point about, you know, is this going to be more like a sort of pocket of consumer law that we have? That's, you know, we leave contract law alone as a main thing, but we have these add-ons that facilitate certain types of contracts. And I think maybe that's the idea with remedies. But the heartening thing is, this is not about starting again. This is not about year zero for contract law. The toolkit is there. It just needs, my sense is, that the call for evidence may give us some different answers to this. But certainly my feeling, bolstered by the stakeholders I've spoken to, is that actually what's needed is modification. So we've already got these things. You know, contract lawyers have been dealing with new problems for hundreds and hundreds of years. So it's just the question of picking out those. The final thing I will say is, I think the other very tricky, thorny point with smart contracts is going to be interpretation, because of course there is no point in asking what a reasonable computer would make of a piece of code, because there is no such thing as an unreasonable computer. So how do we get around that? And one of the suggestions that's been made to us, and that indeed that we agree with, is perhaps to have a particular type of expert witness who is a coder, who could say what a reasonable coder would have made of the code that was submitted to the machine. It's a huge question, and I could talk about that for 2 hours, but I won't.
I'm going to have to stop you, but I think plainly you've given Baris an idea for a future webinar on smart contracts.
Yeah.
That all sounds fantastically interesting. The idea of Adams and Linsell, and then Adams and Linsell in the algorithmic legal order, sounds absolutely intriguing. I think we've got about 2 minutes to go. I'm going to call stumps at 2 o'clock sharp. One question to end with to Andrew, and can we keep it very short, Andrew, because we really have run out of time now, is do you perceive a problem with acceptability of electronic bills of lading and a move to DLT with the requirements of the regulatory bodies? The questioner says an EU report, I don't know how relevant that is anymore, in 2018 certainly seems to think so.
It's an interesting thought that. I can't see why there should be, because I can't see why a regulator should insist on receiving the bill of lading in a paper form. Even in the EU, I can't see why a regulator shouldn't be able to be persuaded to take a printout if it's suitably authenticated.
Maybe, I don't know whether I don't know what the EU report is in question.
That's my feeling about it. I don't think that there's any enormous difficulty there. I may be wrong, and I'm very happy to be corrected.
Okay, well, whoever the questioner was will no doubt correct you in due course. Can I thank our audience? And we started with 149. We now have 127, with only the fall off in the last 10 minutes. No doubt that people have to rush off at 2 o'clock, even in these virtual times. May I thank our audience for being with us. May I thank our 3 speakers, Sarah Green, Andrew Tettenborn and Barry Sawyer, for their very illuminating and interesting presentations, which have certainly given me lots of things to think about. Whether all this comes to pass in a few years or a bit longer, with Barris's view, I don't know, but it's very, very stimulating to hear these views. So thank you all very much indeed, and I will call a halt to the meeting, and I think if the Central Controller, Lynn, closes us down, then that will be the end. Thank you all very much indeed. Have a very good afternoon and keep well.